Hi, everybody. Welcome to Snacks with an Expert. I am Jenna Baggs. I'm the manager and also a member here at Spark Offices in Manchester. We offer an innovative co-working space designed to bring people together to collaborate, to work together, to get ideas sort of flowing. We're kind of a unique, cool space to work as well. We also happen to be the proud sponsor of Snacks with an Expert event series. Today we are introducing you to our expert attorney, Stephanie Burnham. Attorney Burnham offers personalized services to her clients, works closely with them to draft many of the documents she's going to talk about today. She was recognized in March of 2017 by the New Hampshire Bar Association Pro Bono program for her distinguished pro bono service, and is a member of the New Hampshire Bar Association's Ethics Committee and is a chair of the Ethics Committee for a second year. She also serves as an arbiter for the New Hampshire Better Business Bureau. So without further ado, I present Attorney Stephanie Burnham with Necessary Estate Planning Documents 101, what the last will and testament will and will not do.
It's truly my pleasure to be able to offer estate planning advice to my clients. I am happy to be able to share a little bit of that information with you today. Some of the basics and essentials that you might need. This presentation will not substitute for good legal advice, so please feel free to contact me to talk about your particular situation and to discuss your particular recommendations based on your situation, which will be confidential and private and specified. So if you wouldn't mind moving to the first slide, thank you. So there's three ways that assets pass. In the event that you are to die, which unless you happen to be a Highlander, the answer is that's going to be inevitable. There's three ways that you can possibly pass the things that you own on to your heirs. The first way I like to talk about is the one that is the easiest to explain, and that is beneficiary designations. Beneficiary designations are really an agreement or a contract between you and a financial company that says if you pass away, the money that they're holding for you will be able to transfer to a person you name. You do that with a beneficiary designation form. So things like life insurance, 401ks, IRAs, those different retirement type packages, annuities. When you fill out all of that paperwork, and by all that paperwork, I mean an inch worth of paperwork in there, they give you a beneficiary designation form and they say, all right, if you pass away, who do you want us to send that life insurance proceeds, the 401k, the IRA, who do you want us to send that to? And you name the people that you want. You name your primary beneficiary, oftentimes a spouse or your children, or maybe if you aren't married or don't have children yet, it could be your parents or it could be your siblings. Any of those options, you normally name them first. And then what happens when you pass away, once you click the next slide, when you pass away, those people notify the company and the company sends them a claim form. Usually the claim form package comes with them requesting 5 or 6 additional documents. And you go ahead and they will fill all that information out. They'll submit it to the company. The company will lose the first package of information. They'll resubmit it to the company. And about 60 days later, they'll receive the funds. They'll receive the money, or they'll be asked to open up an account at that financial institution so that they can move the money into an account in their name. Some really important things to remember about beneficiary designations is you have to review them. Because filling them out once when you're in your 20s and then not looking at them again for the next 40 years isn't really good planning. Because during that time frame, lots of things can happen. You could get married and divorced. You could have people in your life that you've named pass away. You could have people be born. You could have children during that time frame. And if you're not reviewing these beneficiary designations, you may find, or more likely your family will find, that the wrong people are getting the money after you pass away. Things that really happen a lot, and one of the really big ones is divorce. When somebody gets divorced, a lot of times you figure that after you get your court order and you've separated all the assets, that everything's fine. But if you're not checking those beneficiary designations, every now and then we find an ex-spouse is about to inherit a $400,000 IRA, and the family gets really cranky. Cranky people go upstairs and they talk to the litigation department at my firm. But ultimately, we really don't want that to be the case. So reviewing your beneficiary designations anytime you have a major life event, marriage, divorce, somebody in your family passes away, that's always a good help. And if you don't have any major life events, calendaring to review it every 5 to 7 years is also a good plan. Now, for other stuff that doesn't have beneficiary designations, things like, for example, you can't put a beneficiary on your car title. You really aren't able to put a beneficiary in the same way as you would for life insurance on your house. Bank accounts oftentimes don't necessarily have beneficiary designations. So for things like that, that you own in your own individual name, those types of things oftentimes go through the probate court process. Now, I've listed here a bunch of items that go through the probate court process: cars, RVs, ATVs, boats, trailers, snowmobiles, bank accounts, real estate, US savings bonds, and little stock certificates. If you've ever received a quarterly dividend check from ComputerShare, you have stock certificates. And then accounts that don't have beneficiary designations, maybe your savings account that you set up or your checking account. These kind of assets, if you pass away, oftentimes go through probate court. And people say, well, why? Why does it have to go through probate court? I don't understand. Well, the whole reason probate court exists is because it's all about who owns the asset and who has the ability to sign a document to transfer it. For example, when you want to pay a bill out of your checking account, you sign a check. Well, if you're not there to sign a check, no one is authorized to write any checks out of your bank account. Likewise, with your car title, if you're not there to sign the back of your title to transfer it, then nobody has the authority to sign the back of your title and to transfer it or donate it or sell it. And that's what probate court was designed to handle. Nobody likes the idea of cars just sitting in driveways rusting. No one likes the idea of money just sitting in the bank and not being able to pay bills. No one likes the idea of real estate being left vacant. So as a result, they created a process so that someone can be appointed to stand in your shoes and have the authority to sign documents on your behalf. And that was where the probate court process was generated. It was that the idea was someone would petition the court and say, this person died, they have stuff, and we need to transfer that stuff out of their name and to the people that should inherit it under the law. So they created this process called the probate court process, and the person is supposed to be appointed. And when they do that, they now have the authority to sign documents. Of course, while the judge has them on the hook, they're going to make them gather up all the bills, make sure all the bills get paid, make sure they find all the assets, value all the assets, and then verify that they have in fact transferred all those assets to the people that are supposed to inherit. Now, if you don't have a will, not to worry. The state legislature, in their infinite wisdom, knew exactly how you wanted your assets to pass. They came up with a set of laws called the state intestacy laws. They say, well, if you don't have a will, we know what you want. You must want our state intestacy laws to control where your stuff goes. Now, if you are totally nerdy and love estate planning like I do, you might want to check that out at RSA 561. Little tough going for the reading wise, but still pretty exciting stuff. Important things to know: your surviving spouse doesn't get everything. Turns out you don't get to leave everything to your spouse if you don't do any planning, which is usually a big surprise for that spouse sitting in the office saying, what do you mean I don't get everything and I have to split stuff with the kids? Well, the state legislature thought perhaps if you didn't do that, that you might want to actually separate your assets out. So in many cases, the surviving spouse gets certain assets, but not necessarily all of them. It turns out that the routine rule is the first $250,000 worth of assets goes to that surviving spouse and half of everything else. The other half goes to the kids. And if you have kids from a previous relationship, the surviving spouse only gets $100,000 and then they split everything. So there's a lot of information just tucked into that statute that no one really knows about other than it's bad to die without a will. So rule of thumb, if you don't perhaps trust the people in Concord to know exactly what you want for your stuff, it might be a good idea for you to sit down and do some estate planning. And that is where a last will and testament comes in. Now, a last will and testament. There are so many misunderstandings about what that document does. But for this purpose, I think the best way to think about it is to think of a last will and testament as a really fancy letter to a judge. Now, I have people that tell me all the time, they call me up and they say, Attorney Burnham, I took the will down to the bank and the bank said, that's nice and all, but that's not enough. How come I couldn't just open up, just sign on the bank account? I have their will. It says I'm appointed. It says I'm getting everything. Well, yeah, because the last will and testament is a letter to the judge and the judge isn't at the bank. I don't think that 16-year-old teller really knows exactly what you want to have done with that, or that it's valid, or that they should be honoring it. Even the branch manager probably thinks to themselves, not a lawyer, don't really want to get involved in somebody's fancy legal document here. The last will and testament itself has to go to probate court so that the judge can say, hey, this is the one we're going to use. This is the official last will and testament. It meets all the criteria of the statute. It is what we're going to do. And I am going to appoint the person who is named in that last will and testament as the executor. So the last will and testament replaces the state intestacy laws, but it has to go to probate court. Okay, very important. Now, a last will and testament, it's a really great way for you to name who you want to be in charge and where you want your stuff to go. So again, it replaces those intestacy laws, but it also allows you to control where you want your stuff to go. So you don't have to follow the state intestacy laws, but you also don't have to follow the rule that says your spouse gets everything. And that's really good because a lot of marriages these days end in divorce. And I see a lot of people who are on their second and third marriage, and they have kids from previous relationships that they want to make sure get something. Maybe they don't want it to be that first $100,000 and then split 50-50, but they have these ideas about what they want to do, and a last will and testament allows you to be specific about those things. One of the really big things that a last will and testament does is it is the only place that you can nominate a guardian for a minor child. So if you have kids under the age of 18 and you want to make sure that you have some say in who is going to be their guardian if you pass away while they're young, you need a last will and testament yesterday. And that's kind of key because when it comes to guardians over kids, it's about who petitions the court to be the guardian, and then the judge makes a final decision. And if you don't have a last will and testament that names somebody, then you don't get a say anymore. And now it could be that uncle that you don't trust, or that mom who made your life miserable and you don't ever want taking care of your kids. It's always interesting to see who comes out of the woodwork to take over the care of your children, and especially the care of the money they're about to inherit. So last will and testament is a very fancy letter to the judge, but it's a very essential document. Now, we still haven't gotten out of probate court yet. We're still stuck in probate, and that's no fun for anyone except the lawyers. We like probate court. And the clerks like it because, of course, that keeps them employed. But everybody else usually pretty much tells us it's a huge hassle and they hate it a lot. And when will it be over? And why can't it be over yesterday? And as you can imagine, it's never quick. In fact, right now, if you petition the probate court, we've been waiting about 90 days for people to get appointed from the date we actually file all the paperwork. And the court so kindly just told us today that they'd get to our petition when they got to our petition, even though we had filed it back in November. So yeah, not a quick process. And so we really oftentimes try to get everybody out of the probate court process. One of the ways we do that is through trusts. Now, trust can be used for a lot of different things. And so as a result, you can find a lot of different names for trusts out there. People sometimes talk about realty trusts. They talk about family trusts. They talk about living trusts. They talk about life insurance trusts. They talk about Medicaid trusts, all sorts of different names. There are only two types of trusts. It's either revocable or it's irrevocable. If it's a revocable trust, that means that you can change it during your lifetime. If it's irrevocable, what you create and when you sign it, it becomes set in stone. and now it's not something you can change. And they have different reasons. Most trusts that people create are revocable. And that is because they're using it to substitute for that will. Instead of having your bank account go through the probate court process and be stuck at the bank for 90+ days while you wait for your executor to be appointed, and rather than waiting for the car to just sit in the driveway for 90+ days, and rather than waiting and trying desperately to come up with the money to pay the mortgage and property taxes on the house they can't do anything with because no one's been appointed yet for 90 days, trusts can substitute for that option. The revocable trust is that will substitute because it is something that is designed to be changeable during the person who creates its lifetime. Meaning that just like a will, as your family changes, you can change the terms of the trust. So you might start out, if you have young kids, with something where you start out in charge, but then you might be picking your brother or your sister or your mom or your dad to manage the money on behalf of the kid while they're young. But then as the kids get older and then they become more in control of their destiny and they become adults and then they become parents, you may transition them into a role where now they're going to receive their inheritance outright rather than receiving it, part when they're 25 and part when they're 30. You can change the terms of the trust, which makes it something that's very flexible and easy to work with. What's also great about revocable trusts is that when you create a revocable trust, it's still your stuff. So a trust itself really is a legal entity on fancy paper that has the right to own stuff. And when you think about it in terms of an abstract definition like that, it's kind of like, I don't really know what a trust is. But if you think about it in terms of a small business, and a lot of people here are small business owners, or are creating their own entities and working their own businesses. When you create a small business, you are creating a legal entity on paper that has the right to own stuff. You can own buildings, you can own cars, you can own bank accounts, you can enter into rental agreements on behalf of that legal entity, and a trust works the same way. So here you create this, Susie Smith's family trust, and you can deed your home into the trust so that on the registry of deeds, it says Susie Smith Family Trust. You can even put that on the back of your car title and have your car registered in the name of Susie Smith Family Trust. It can be at the bank in the bank account titled Susie Smith Family Trust. And so all of these assets that are owned by this trust, now what we have is we have the same thing you had when you created your business entity, a situation where this document says who's in charge and who has the right to take over. Now, when you're an individual and you pass away and you're the only person authorized to sign on your checking account, somebody has to be appointed to sign on your behalf because anyone trying to sign your name is now committing identity theft. But when you have a business or you have a trust, the document actually says who's in charge when you're not available. So in the trust, the first person who's in charge is always called the trustee. That's the manager. The trustee's job is to balance the checkbook. They are supposed to make sure the property taxes are paid on the real estate. They're supposed to go ahead and make sure that the car is registered and insured. They have all the work to do. Managers have all the work to do. That's the trustee. And in a revocable trust, that is usually the person who creates it, or you. So if you created a trust, you're the first trustee. You're balancing your checkbook, you're paying your bills, you're living. Oh wait, you're doing the same thing you did when you owned the house outright. All right. So nothing's really going to change in your life. When you are the creator of a trust, you also get to be what's called the grantor. That's a really special title. The grantor is the owner of the trust, which means you also own everything in the trust. So you get to live in the house rent-free and no one can make you pay rent or evict you. You can drive your car. You can take money out of the ATM. You can sell everything, buy a boat, and spend the rest of your life cruising in the Caribbean. I know that's what we all want to be doing right now. You have the right to do this because you're the grantor and you're the manager, which is the person who signs on the dotted line as the trustee. So you get to do whatever you want. And then you're also the person who gets to change the terms of the trust. So your life really hasn't changed anything at all, except that when you pass away, way into the future, when you pass away, what you have done by putting those assets in that trust is made sure that you have named that successor trustee, the person who takes over after you. And that person now takes your death certificate to the bank and says to the bank, see, the trustee passed away and I'm in charge next. And now instead of the bank saying, gee, I don't know what to do with this document, they hand them a signature card and say, here you go, sign on the dotted line. And do you need any extra checks? And now we're talking about the difference between waiting 90 plus days to be appointed and we are waiting only a week, maybe 2, to have access to that bank account, to start getting bills paid, to make sure the mortgage doesn't go delinquent. It's a huge difference in time. Not only that, but you have the ability of really controlling how those assets are going to be managed for your heirs. So if you have children who you haven't yet discovered whether or not they're going to be good with money because they're still under the age of 18, a trust can be a really great way of saying you don't want them to get all of the money right away when you pass away. You want them to get money over time. Earlier, I alluded to the idea that you could say that you want your heirs to receive half of their inheritance at age 25 and the rest at age 30. You can set it up so someone is managing that money and they can access it with the consent of the manager, the trustee, for their health, education, uninsured medical expenses, if they need a car. What's really great though is the trustee can say to them, absolutely, I'll help you get a car. You need to get to school, you need to get to work. Here's $20,000. And when the kid says, you know, I really had my eye on that Porsche 911, the trustee can say, yeah, that's nice. Here's your $20,000. So it gives you that check and balance just a little bit to make sure that those kids are getting the money at a stage in their life where hopefully they're making better choices. And if their choices at age 25 are still a little questionable, at least they haven't spent all the money yet because they can get more at age 30. But again, it's revocable, which means you can amend or change it. So as your kids get older and they start to grow into their maturity when it comes to money and they start to make those more mature decisions, you can now change it to them getting it outright. And they may even become your successor trustees rather than your brothers and your sisters or your parents at that point. So it's a really cool document that avoids an entire court process that no one really likes. And lately it's been a little bit more onerous than prior years. But that really gets you away from that probate court process, puts you in control of where those assets are going, and can even be the beneficiary of those assets I talked about earlier, like life insurance and retirement accounts and things like that. So if you're worried about having to leave a life insurance policy with your children there as the beneficiaries, you can use a trust to receive those proceeds so that an adult can manage that money until it's time for them to inherit. A lot of times people have rather large life insurance policies, and you might not want to put $500,000 in the hand of your 18-year-old child. So rather than doing that, a trust is a great vehicle in which to receive those assets. Okay.
I do have a specific question that came in through the chat about the trusts before we move on.
Yes.
Alex wanted to know, can a trust protect your assets, your house, your property, your bank accounts from a potential lawsuit?
So a revocable trust cannot, because remember how I said you could sell everything, buy a boat, and spend the rest of your life in the Caribbean? If you can do that, then they say you can pay your bills with the stuff that's in there. However, remember how I said there were 2 types of trusts out there? That irrevocable trust, that one might do it. And the reason why is irrevocable trusts are created for very, very specific purposes. They are created to hide assets from nursing homes. They are created to avoid estate taxes. So if any of you have more than $11 million that you're trying to transfer to your kids, feel free to contact me. I know exactly how to use an irrevocable trust to minimize those estate taxes. If, like me, you're just a hair under that mark, not to worry about estate taxes just yet. Irrevocable trust can also be used to protect against lawsuits and creditors when it comes to the person who creates it. But the reason why irrevocable trusts offer protection is because they also are very limiting on what you can do. So for example, with an irrevocable trust, you might not be able to sell everything, buy a boat, and spend the rest of your life in the Caribbean. Instead, it might say you only have the right to income from the trust. So whatever the investment is generating, that you might have access to. But the stuff that you don't have access to, that's going to be protected from your creditors. Interestingly enough, most people really don't need to make those kind of transfers unless you're getting closer to your 80s. And the reason why is a lot of times you need these assets to live on. You need these assets to be able to be flexible and to do things like that. So I don't oftentimes recommend irrevocable trust for people because while they can offer that protection, you are very limited as to what you can do with them. And if you are being sued, you can't create one and transfer assets into it because you know you're about to get sued. We have a statute called the statute of frauds. And the statute of frauds will not allow you to transfer assets to somebody or something like an irrevocable trust if you know you're going to get sued, or if you know you might have done something that will rise to a level of being sued. They'll invalidate your trust and you will have spent a lot of money with an attorney not getting what you want done. But they are good for nursing home protection. Again, come see me when you're in your 80s, if I'm still practicing law and not retired. Then we can talk about, putting a house or putting very specific assets into a trust so that if you do go into a nursing home, you can protect those assets. Now, that being said, you may or may not want to, and that'll be a discussion that we would have based on some of the limitations that come with this balance of protection. If you are between 50 and 60 years old and you're healthy, one of your better bets is to look at long-term care insurance, because that will allow you to control what facility you might go to and will give your family a lot of protection, as well as the ability to keep a certain level of care and not worry about having to qualify for Medicaid to pay for long-term care and nursing home care. So I hope that answered your question, Alex. I will say this, though. There is one instance in which the revocable trust, if you want to go back a slide to that, can offer some protection against creditors. There you go. The one instance when a revocable trust can offer protection against creditors is when your children are inheriting but haven't inherited yet. Most attorneys, I know I do, will actually draft a clause into the trust called spendthrift. The spendthrift clause is designed to protect the money you want to go to your kids from their liabilities. So if you have a kid who married somebody that perhaps you're not all that fond of, and you're thinking to yourself that marriage might only go another 5 or 10 years, and you want to ensure that your child doesn't end up having their inheritance pulled into their divorce proceeding, the spendthrift clause in a trust will help do that. So a spendthrift clause allows the trustee to hold the money in case you have a beneficiary who's being sued, going through a divorce, dealing with creditor issues. If they have a substance abuse problem, you can get language in there so that if they're dealing with a gambling problem or another addictive situation, that the money you're planning on having them inherit doesn't outright go to them in the middle of that lawsuit. So that is one way a revocable trust can protect your heirs. But once the money leaves the revocable trust and it goes from the trust to your kids' hands, all bets are off. Now it's theirs to do whatever is going to happen next. And so if they haven't yet filed their divorce and they haven't mentioned to the trustee they'd like them to hold the money a little bit longer, then the money can be pulled into the divorce if it's already been put in the hands of the kids. Prenup is a little bit beyond the scope of what we're talking, but prenups also are very helpful in that instance. So revocable trust benefits allows the control, irrevocable trust, very specific purposes, avoiding estate taxes or minimizing estate taxes. If you live in Massachusetts, your estate tax threshold is $1 million. You probably have an estate tax problem. So you should definitely see an attorney licensed in Massachusetts. I am licensed in Massachusetts, but you should see an estate planning attorney about that, because pretty much your house and life insurance will set you right over that limit, especially in today's real estate market. And your family will be paying estate taxes if you are a resident of Massachusetts, unless you start to use some of the tools like irrevocable trusts and limited liability companies. Again, a little bit beyond the scope, because it's going a little bit above and beyond 101. But there are tools you can use to try and minimize those taxes. And then, of course, irrevocable trusts are also used for nursing homes. So think parents or grandparents who might be concerned about going into a nursing home. A diagnosis of Alzheimer's is a circumstance in which we start talking irrevocable trusts. MS, Lou Gehrig's, a lot of these degenerative illnesses where it's entirely likely somebody may end up needing facility care simply because their physical body just won't be able to be at home. These are circumstances when we start talking irrevocable trust. But again, definitely talk to an estate planning attorney if you've got any circumstances or concerns about that. And we'll make sure that you don't have any of those risk factors that would result in wanting one now, because you can always add one later. All right, so let's move away from death, because after all, we don't want to end this on a down note and completely only talk about dying. Let's talk about what happens while you're alive, because there's still some estate planning documents that you might need while you're alive in the event you are dealing with a circumstance beyond your control, like a car accident that puts you in the hospital. You know, there are documents out there that you might use. A durable power of attorney is probably what I consider the second most essential document. Trusts are amazing, super useful tools. Are they essential? It depends on what your goals are. Wills are essential because that's the only place you can name a guardian for minor children and get rid of those pesky intestacy laws. So wills are definitely the first. The durable power of attorney is the second. The trust is amazing. Is it essential? It depends on your circumstances. But a power of attorney, what this does is this appoints someone you trust to be able to manage your financial affairs while you are alive. Okay. Now there's two different types. There's one that is immediately effective, called a durable general power of attorney. And then there's one called a springing power of attorney. It springs into existence when some kind of an event happens. So you have a car accident and your doctor says, oh yeah, this one's going to be in a coma for a couple months. That would be a good example of why a durable power of attorney might spring into effect. Your agent, the person you name to be that person, would need to ask the doctor for a note certifying that you're actually incapacitated. And then they could go to the bank and balance your checkbook. They could cancel your credit cards and get them reissued if your wallet goes missing at the scene of the car accident. They can make sure the health insurance company is working with the hospital billing department. It's their job to take care of these bills for you when you can't do it for yourself. Now, springing exists a lot of times when people are not married and they have family or friends that would serve that role. The more common one is the durable general power of attorney. That one is in effect the moment you sign it. And the idea there is you don't have to ask the doctor, you just have the authority, the person will have the authority to act in your best interest, no matter what, at any time. So you could be on a cruise somewhere and somebody could be doing something like breaking into your house, and your durable power of attorney could make sure that new locks are installed and arrange for that to all happen because they're acting on your best interest. They could be the ones talking to, you know, the police officer and trying to get all this stuff together. They can be acting on your behalf, even though you're not incapacitated, you're just not there right now. Now, one of the other durable powers of attorney that exists are ones that are used for very specific purposes. Now, a durable general oftentimes just says, hey, I trust this person to be able to do anything. And that's great. We use those a lot because we don't really know why we might need them. We just know we might need them in the future. You can tailor it to be a specific reason. Sometimes powers of attorney are used when, for example, people are closing on houses in different states. Somebody was selling a house here in New Hampshire and buying a house in Arizona on the same day. Turns out they can't be in two places at once. And we still have not gotten to the level of Star Trek transporters. So what we can do is we can name somebody a durable power of attorney so that they can sign those closing documents in one of those states for you while you are at the other closing. So we use those, we call those limited powers of attorney because they exist for a limited purpose only for a certain time. Now, powers of attorney are revocable at any time, just like those trusts. So you can name a power of attorney, and then if you're really worried that they are making some really poor choices in their life and you don't want them to be your power of attorney anymore in case something bad happens, no problem. Rip it up, be done with it, create a new one with somebody else. You absolutely can change it at any time. And there's no rule that says you have to have some legal capacity to do it. So for all intents and purposes, you could be hallucinating and you could revoke your power of attorney if you had the wherewithal to do it at that time. So a power of attorney is not a permanent thing. It only is in effect while you're alive. So if you've ever been named someone's power of attorney and they die, please don't go to the bank using the power of attorney and trying to do banking for them after they die. The power of attorney goes with them, and you may be accused of doing things you're not supposed to do with a document that was invalid if somebody catches on to the fact that you are using the power of attorney to do stuff after they die. It only is in existence while you are. Now, it avoids guardianship proceedings. A power of attorney can be a great tool because if you don't have one and you're in the hospital in a coma, somebody still needs to pay your bills. And if that happens, somebody's going to petition the probate court to have you declared legally incapacitated. Think Britney Spears. She was declared legally incapacitated. And everyone knows, especially in the last 6 months, because gosh, I've seen her name more in the last 6 months than I have since the 90s. In any event, everyone knows that it's really hard and she still is under those guardianship. They call it conservatorship in California, but she's still under those proceedings because she was declared legally incapacitated. So if you're in a coma and your friend petitions the court to have you declared legally incapacitated, in order to get out from underneath your friend controlling your money and everything else, you have to be declared legally capacitated again by a judge, which means you have to go back to the probate court and ask the judge, pretty please, would you take this guardianship away? Power of attorney means that nobody has to have you declared legally incapacitated, which means when you wake up from your coma and they hand you your checkbook and you say, oh my gosh, what have you been doing? You can take over right away and balance it and make sure everything's there without having someone declare you legally capacity with legal capacity. So guardianship can be a good thing to avoid, especially if you want to be able to seize control of your affairs the minute you are back to being able to do so without having to wait for a hearing by a judge. Because as we mentioned, they're a little bit behind right now. So the second power of attorney that comes up is called a power of attorney for healthcare. A lot of times they're called advanced directives. If you live in Massachusetts, they're called healthcare proxies. This is somewhere where you appoint someone to be able to make medical decisions for you if you are unable to do so. The doctor decides whether you are unable to do so. So if the doctor is trying to talk to you and you only are interested in talking to the big pink fluffy elephant in the corner, then the doctor is going to activate your power of attorney for healthcare and say, they can't make a medical decision right now because they refuse to talk to me. So I'm going to look at this document and see who they said they trust to make those medical decisions. Now, there is a law, there is a statute that allows people in your family to make decisions in emergency circumstances. Usually emergency circumstances have to be short durations. If it's going to go for a couple of weeks, the doctors oftentimes will say somebody needs to be appointed the guardian of the person who's incapacitated if they don't have a power of attorney for healthcare. Again, now you've got a court saying you don't have the ability to make decisions and will not allow you to make decisions for yourself, even if you're in the hospital room and competent, until the judge says you have the ability to be competent, which means that you might actually not have the ability to make medical decisions for yourself for a longer period than is necessary because you just simply can't get out of the hospital to go see the judge. So a healthcare power of attorney allows you to pick the person you want to make those medical decisions. That can be really important if perhaps you don't think the same way as some of your family members do about end of life care. Or you have family members who don't make good decisions in emotional circumstances, or can't make decisions when put in any kind of pressure. This is a great time to talk about what kind of decisions you would want made for you if the unthinkable happens. This is where you can tell them, if I am terminally ill and there's no hope of recovery, please don't put me on life support. I don't want to be living in a hospital bed hooked up on machines that make my body be if there's no quality of life. It's an opportunity for you to say, if you're permanently unconscious, not a coma, people wake up from comas. We're talking permanent vegetative state. And you can pick the vegetable. You can be broccoli or cauliflower. If you are an asparagus, you can say you would prefer that they remove life support and not promote the vegetable colony. You have the ability of deciding what kind of medical procedures you would or would not want. Oftentimes we add language to our healthcare powers of attorney for people who have religious objections to certain types of treatment, or are very devout and want to make sure they are following the teachings or the scriptures of their particular faith when it comes to end of life decisions and when it comes to making medical decisions about it. It allows you to authorize people to consider experimental treatments or clinical trials if it's appropriate in your circumstance. And you might be in a situation where it might be helpful to try something like that, but you can't make the decision for yourself because the medication you're on has created a circumstance where you can't actually interact with the doctor as well as you would need to really consider it. Other things the power of attorney for healthcare can do, it can allow your agent to be able to overrule your refusal for medical decision-making, which sounds like a little bit like crazy talk, because why in the world would you want somebody to be able to overrule you? But being able to overrule someone who has Alzheimer's and is refusing necessary medical treatment because they don't understand what's going on and are outright just saying no, 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 can be incredibly helpful into having them recover from something like a urinary tract infection, which causes their Alzheimer's to spike and causes irrational behavior. It can be essential if you've been given medication that has caused you to want to converse with that big, pink, fluffy elephant in the corner, and they've convinced you the nursing staff is trying to kill you. So you're refusing medical treatment, even though the medical treatment might cause you to get out of that situation or to get better. So it gives you the opportunity to say whether you trust that person to be able to overrule your no. They don't have to, but if you give them the authority to, they could. It also is an opportunity for you to specify in some detail what kind of circumstances you might want your family to not look at life-sustaining treatment. Alzheimer's comes up, that's a big one. That's now listed in the new power of attorney for healthcare. For those of you who don't follow estate planning as closely as myself, the new healthcare power of attorney law went into effect in July of 2021. We got a whole new form for the living will, and it includes language that allows you to say that you perhaps don't want life support if you get to the end stage of Alzheimer's and no longer recognize your family and friends, and you're refusing to eat. You might not want a feeding tube, and you can specify those kind of things. So there's a lot of things that you can do with that healthcare power of attorney, not just avoid somebody who shouldn't be making medical decisions for you, making them when you're not able to do so. So that can be a really, really powerful document. Those are really the basic essential documents that I think any estate planning attorney is going to want to talk to you about. So if you're talking to an estate planning attorney, you're going to definitely want to talk about a will, a power of attorney for finances, and a power of attorney for healthcare. Do you have to have all of them? No, but you definitely want to make sure that you've talked to the attorney and determined whether or not any of them might be appropriate and fit your goals. And then there's the fancy one, that trust, which you also might want to consider as an option in your estate plan if you have any concerns about the idea that you need to control how the money is passing to your heirs, or perhaps you might not want to wait for the probate court judge to get to that petition in their pile when they get to it. But I'm happy, we've got a little bit more time, so if anyone has any additional questions that they might like to ask, if you want to send that into the chat, I'm happy to answer those. in the meantime, thank you very much for coming. I'm glad you were able to come and that you're taking the opportunity to learn some more about estate planning documents. And thank you very much to Spark for having me here. It was a pleasure.
Yeah, thank you so much. I actually have a question.
Great.
This is for myself. So as you were talking about the healthcare power of attorney, it sent me back, the way you were describing it, sent me back to the will, where you said the will sort of becomes this letter to the judge. Is that sort of how the healthcare power of attorney can be seen? Because you said there's places to sort of discuss how you would feel about maybe some end of life decisions or decisions about trying experimental treatments. Is it seen, could it be seen more that way? I think
it's
actually an emotional person that appealed to me.
So the thing about a power of attorney for healthcare is that it doesn't have to go to a judge.
Okay.
The power of attorney for healthcare gets activated by the doctor. And the doctor says that you're not capable of making medical decisions. And therefore, the people that you have named are going to substitute for your decision making. And that gives the people in your life that you trust to make that decision the ability to evaluate whether or not this is appropriate. It gives them the opportunity to say, you know, I hear what you're saying, doc, but what, you know, I want a second opinion, or I want a third opinion. It gives you the opportunity to really evaluate what's going on there. And if there's any kind of controversy or argument, you know, in your family about what should happen next, it does provide them guidance. Many times the actual facility will encourage the family to follow what you've written in there as guidance. So that does give you that opportunity to really say what you want there. But does it have to go to court? Not unless somebody files a petition at the courthouse saying that they want to be appointed your guardian and they want the power of attorney for healthcare set aside because the person there is making poor choices.
Okay. That's a good distinction. Thank you. Emily says, this was really great. Thank you.
Oh, you're very welcome, Emily.
So to follow that up, what's the best way to get sort of, okay, so it's all Greek sort of to us. What's the first step in doing something? Because now we know we have to do something. Right. What's the first step?
So the first step is to make an appointment to talk to an estate planning attorney. In my office, when people call up, we schedule either Zoom or telephone conferences. We are doing some in-house appointments, but I'm finding a lot of people are kind of liking the idea of being able to just Zoom and have the meeting in the comfort of their own home or at their office so that they don't have to drive. And we'll set up the appointment and we'll send out a questionnaire. And we ask you to give it your best shot. All right. I have lots and lots of people who say, I didn't fill out the questionnaire. I'm like, okay, just fill the first couple of pages where it says your name and who your kids are, and then we'll go from there. But you fill out a questionnaire and then you'll sit down and the attorney is going to ask you questions. We want to know why, what got you here? You know, what was it, you know, an estate planning seminar? Was it a conversation with your friend? Was it the fact that you just had to probate someone's estate and you are now horrified at the idea that anyone should have to do this again? You know, what was it that got you there so that we can start talking about what your goals are? Any estate planning attorney who's been doing this a while will get you there, even if you have no idea what you're doing. We will help you by asking you questions and listening to what you have to say and picking up on some of the things that you might say about your family that you didn't even realize you were saying out loud until we said, so what I got from that was this. They were, oh yeah, that is what I said, isn't it? And yes, it's true. So that will be something that will get you there. When we get through our initial consultation, I normally have a good idea about what my clients want, or you have a good idea what questions you need to answer. Because sometimes, even though we ask all the questions, you just haven't made up your mind yet, and that's okay. What we'll do is we'll send you away with those questions for you to talk about, and then hopefully come up with a follow-up appointment so that you have that deadline. Because every now and then, when people don't have a deadline, they procrastinate. And procrastination is the enemy of the estate planning attorney.
So if someone already has a will,
yes,
coming in and reviewing it is always a good idea.
That's a great idea.
And then maybe some suggestions about what else might need to exist is also something that you could take care of.
That's normally exactly what happens. So if they have a will, I have a lot of people who say, I did a will 20 years ago. I said,
Exactly.
that's awesome. I'm so glad you did a will 20 years ago. Let's think about what your family looks like now. And, you know, the last time I had an opportunity to do my own parents' estate plan. And the estate plan that I saw indicated that I was being left to a family member as a guardian. I was 30. So, you know, as you can imagine, these things, you know, at least you got it done. And then it's time to review. If you have done your estate plan in the last 10 years, my rule of thumb is review your estate plan every 7. 7 years seems to be just that magic number where kids really transition a lot during that age group. Families transition, laws change. 7 years is just a great way of sitting down and reviewing what you've got for powers of attorney, reviewing what you've got for wills, making sure these people haven't moved across the country or haven't done something really strange like moved into a commune. It's a great opportunity for you to look at it and say, you know, has this person become more responsible or less responsible? Are they the right person to be doing it? So a 7-year review is usually what we do. I send out letters to my clients saying, hey, it's been 7 years. Most of the time they'll say, oh my gosh, I can't believe it's already been 7 years. Nothing's changed. And it's like, that's great. We'll see you in another 7. Sometimes people come and say, oh my gosh, I'm so glad you did this because I've been meaning to call, but I kept forgetting. And then the letter came and it was like, I have to call now. So, you know, checking in and making sure that these documents really are going to do what you want is key. And then when it comes to choosing the right estate planning attorney, make sure that whoever you work with is somebody you feel comfortable talking to. If you meet with an attorney and you really feel as though you don't connect and you don't feel necessarily like that's the person that you can really talk to about everything, shop around a little bit, because when it comes to estate planning, you really do kind of need to tell them everything. We need to know if one of your kids is kind of a jerk. We need to know if you've got a family member that really makes you uncomfortable and you want to make sure that they never have access to your kids or your kids' money. And that can be a really uncomfortable conversation to have, especially if you don't connect with the attorney that you're sitting there talking to. Estate planning is personal, so you need to be able to have that conversation.
That is a perfect way to end this. I couldn't agree more. Thank you so much, Attorney Burnham, for being here today and sharing clearly your passion on this topic with us. We appreciate it.